legislation associated with vital statistics or anything else. First place to always go to is definitions, of course. And so what is a birth? Well, okay, it seems to generally relate to a human being, right? It doesn't say human, it doesn't say man, it doesn't say woman, it doesn't say child, it doesn't say anything. It's something that has these these aspects, right? So they could be talking about a cow or a bird or anything, right? All right, well, have a good night. Take care, Kathleen. Definition is very open, and there's some theories that they're dealing with people in the capacity of some sort of animal, not a man or woman, etc. So that's always of interest. So anyways, what's the definition of certificate? It means a certified extract of the prescribed particulars of a registration filed in the office of the Registrar General. So I look at all the different elements of the definition. Certified extract, prescribed particulars. So there are particulars they want. They're prescribed in some legislation. They're going to be prescribed here in the Vital Statistics Act, right? And of a registration filed. So the registration has to be filed. And that's another thing that's come up recently is just because you send it in, filing it doesn't mean it's on file. Possibly we filed it, but they haven't put it on file. That's another thing. So there may be games associated with that. There's some other words in there we don't really care about, but given name means a name other than a surname. So they're creating a distinction, obviously, between the given name and a surname. Well, that raises the question, what's a surname? All right, we'll get to that in a moment. Incapable is used multiple times in the Act. It means unable because of death, illness, absence from British Columbia, or otherwise. Well, if they can't find you in British Columbia and they deem you to be a Canadian resident, a resident of Canada for tax purposes, you are absent from British Columbia. So you may be deemed incapable to deal with this information and process, etc., or otherwise. Could be declared dead or whatever. So incapable, when you see it, has a meaning which could be interpreted in some of the ways that have been raised as possibilities. Midwife is another interesting one. It means a person who is registered as a member of the College of Midwives. So a midwife in this act is only somebody who's registered as a midwife. So if you have a midwife who's trained as a midwife but not registered under this act, they're not a midwife. Therefore, they don't have any obligations under this act, even though they call themselves a midwife. They are not registered as a member, therefore no obligations attached to them under this act. Occupier, generally speaking, public, private institutions, which is like hospitals, proprietor, manager, hotel, inn, apartment, lodging house, or other dwelling, or accommodation, other dwelling. So this could be somebody's home because they call our houses private dwellings. So an occupier of your home. So they cover the bases on that one. Parent means parent under Part 3 of the Family Act. So what does it mean? I don't have that automatically handy, but you got to go over there to find out what it is. Registration under this act of the particulars. So the registration is specific to using the form under this act of the particulars, and the word particulars is particular. Surname means hereditary name, family name, or last name. What does this mean? Surname means there's three options. Could be a hereditary name, or it could be a family name, or it could be a last name. What's the distinctions? What's the difference? Well, common law, it's called a family name or hereditary name. Last name is generally the system and what they call it. Whether it makes a legal distinction or not, I'm not sure, but there is options there. So I always make a distinction that I'm using a family name, so it doesn't come under the other two. Okay. Vital Statistic Registrar means a Vital Statistic Registrar appointed under Section 33. So there is a registrar, he is appointed. Now look at this. This is where it gets interesting. Duty to give notices of birth. Now look at this, reporting of birth. So there's a duty to give a notice, and there's a reporting of birth. They're two different things for two different persons or different types of persons. Who has a duty? Well, the person who has a duty is somebody subject to an act. The person who reporting it is not subject to the act or the duty, but is doing a different process. So duty to give notice is for only a medical practitioner, nurse practitioner, or midwife. Who's a midwife? Somebody registered as a midwife who attends a birth. Now this is neutral, a birth. They use birth of a child when it comes to the parents reporting it, but they only say a birth when they talk about these registered people. So they're non-specific as to what the birth is of in this case. And if none of these registered people are there, the nurse or other person who attends must give notice of the birth. So any other person who attends must give notice. Well, that's anybody who has a duty, which is any other registered person. If a birth takes place at a hospital, the persons having control or management of the hospital are satisfied the notice of the birth will not be given in a timely manner as required. The notice of birth must be given by or on behalf of the persons having control or management of the hospital. So even if the parents don't fill out a form reporting a birth, the hospital has an obligation under law to give notice of the birth if they believe the family or somebody else isn't going to do it. So nobody's born in a hospital without notice being given to the vital statistics based on this section here. The hospital has an obligation to backstop these people if they don't do it, or the parents if they're not going to do it. If notice of a birth is given under Section 3 here, subsections 1 and 2 do not apply to the birth. So if the hospital does it, 1 and 2, these people have no obligation to do it. So I bet you the hospitals do it as a matter of course, and that removes the obligation for these people to do it. A notice under this section in the form required. So there's a specific form by the Registrar General must be delivered to the Registrar General within 48 hours of the date of the birth. So within 2 days, the hospital has to give notice, legal notice of the birth with the particulars. All right? Now, reporting of the birth within 30 days after the birth of a child. Notice, not the birth, but birth of the child. A statement, not a notice, a statement in the form and containing the information the Registrar General requires respecting the birth must be completed and delivered to the registrar. Notice how they're using the term delivered. All right? Here, notice of birth must be given. All right? So again, the terminology changes depending on whether it's a duty of a statute person or whether it's the parents. Now, in the notice, let's see, the statement given by the mother and the father of the child, or by the mother's child if the father is incapable. What did we talk about incapable possibly meaning? Absent from British Columbia, dead, missing, or the form is filled out in such a way that it disconnects him from the child, so he's not, even though his information on the form, he's not connected to it. So if by the child's father, if the mother's incapable or deceased. So there's legitimate coverages here, and then there's secondary interpretations, of course. If neither parent is capable, well, if both parents were born in British Columbia, have never claimed their certificate of live birth, and they're residents of Canada, they are absent from British Columbia. Therefore, they're incapable under the definition of incapable. Or if the mother is incapable or deceased, father is unacknowledged. Well, if you haven't claimed your birth certificate, you're unacknowledged. If you're not on the form properly, you're unacknowledged. Then by the person standing in the place of the parents of the child. Who is the person standing in the place of the parents of the child? Well, it could be the doctor, and that's what I hear from the researchers in the States, is that it's the doctor who is standing in the place of the parents in the reporting and the giving of the notice. And if it's not him, then it's the hospital who has that duty in order to do it. So you can see how the game may unfold in the hospital associated with the registration. If no person delivers a statement, that is the parent's statement, to the Registrar General, the Registrar General may prepare the statement with the information provided in the notice of birth received. So the parents don't provide a statement because they don't want to register their kid. They got a notice from the hospital without the parents being aware of it, and the Registrar General goes and takes that notice and fills out a statement and does it because the parents haven't done so. If the statement made by a person under 1C or D, the person making the statement must make and submit the statement of affidavit setting out the facts that require the statement to be made by the declarant. So this is if it's a third party. So the person standing in place of the child, they're just going to fill an affidavit saying, I was there, I saw the baby born, and yada, yada, yada. So there may be a standard affidavit that the doctor or the hospital fills out. when they submit their notice. So you can see the process is here, and the titles of things are very, very specific. Notice versus statement. If a statement is completed by only one parent, which seems to be the way the forms are generated to be filled out by only one parent, the Registrar General must amend the, must amend the registration of birth on application and payment of the prescribed fee. Now this is where you start to, these are things to pay attention to, for me, with regards to process in British Columbia. In my case, my dad filled it out, so only one parent filled it out. Their both information is on there, but my dad's all my dad's information is in a box separating it from my mother's and my information, etc. So he might fit the category of only one parent filling it out and being separated, etc. So could fall into this. I could send a notice to the registrar to amend the filing to properly credit my parentage to the birth process and the child that was born at that time, etc., where right now it may not be credited. So this is a thought process. And so, and the Registrar General must amend. It's a mandatory, the registration of birth and application. So you have to make an application to correct the record. And this is what it's all about. The record's incorrect right now. And the idea is, what do I do? Who do I write to? What do I say? So sending notice to the Registrar General to amend the registration of live birth with this following information because of the errors associated with it. All right? Now, the person or persons, okay, any of those people can noted above can be the one sending in for an amendment. A parent to the child if the application accompanied by a copy of an order of the court declaring the child's paternity. So this is generally for questions about paternity, but guess what? If you've been declared to have no parents or be a bastard or whatever, getting a court order or a court decree acknowledging your parents is where this could be as a part of your notice to the Registrar General in order to correct the record. So that's another thing there. Now with regards to the name of the child, the surname of the child must be registered. So this is a must. Okay, the surname. And what's a surname? It's one of those three things. If only one parent completes a statement, the surname must be the one chosen by that parent. So there's all these options. If there's two parents, hyphenated names, that type of stuff in there. Court order respecting a child's name. Obviously, there's fights about parents who are divorcing or divorced or not married about how to name the kids. So that's one aspect. Another interpretation is always possible as well. The court may, in an order declaring a child's parentage, make an order that the registration of a child's name be changed. And so, again, getting a court order to correct, in this case, in my case, my dad filled out the form in all capital letters, and so it's the wrong style, and then all my documentation has the wrong style on it as well. So it would be, in my case, not a name change, but information corrected in terms of the style of the case of the letters. And this is an interesting distinction here. Before making an order under subsection 1, the court must consider the best interest of the child. If the child is at least 7 years old of age but less than 12, consider the views of the child. So this 7-year age time frame comes up many places and many times, as does the age of 12. If the child is 12 years of age or older, have the child's written consent. So at the age of 12, they have to get written consent, which means you have some legal consent capacity deemed by the law system at the age of 12. The Registrar General must amend the child's registration of birth and a birth certificate issued making the amendment, etc. So there is amendment processes here within the Vital Statistics Act. Now some people don't register their kids right away. Now, birth registration within 1 year. If within 1 year of after birth the Registrar General receives a statement, statement means it's from the parents, as the notice is from the statute people, in the form required. So what is the form required? It's probably just the regular registration of live birth. Then they must register the birth. All right? Now, birth registration after 1 year. If the birth is not registered within 1 year, an application for registration is made by the person, the Registrar General, in the form required and verified by affidavit. So now you got additional obligations in terms of proof, and accompanied by a statement in the form required by the Registrar General respecting the birth, and other evidence as may be prescribed. So this is where communicating with the Registrar General saying, I need to make this change, I need to do this in this period, I need to have the form, I need to know what the affidavit contents is that is required, I need to know what the statement in the form is required, and I need to know if there's any other evidence required. So this is part of what I'm doing now, is communicating with the Registrar General to get the forms and the processes to do the amendments that I want to do. Now, some people say that there's a penalty if you don't register your kids, right? Or the parents don't do it. Well, yes and no. There's no penalty. There used to be a cost. It's free if you do it within 30 days, and it was $10 if you did it within a year. Well, those are gone from these two registrations for the parents. But later on in the Act, and I'll mention it to you, is a $50,000 penalty. And many people go, well, there's a $50,000 penalty if you don't register your kids. Well, when you read the penalty, you'll see that it's not related to the parents' registration. It's related to the legal notice by the statute persons and the hospital, etc. So there is no penalty whatsoever for the parents not registering the child's, but there is a penalty for a statute person who has a duty and does not do their duty, and we'll show that to you in a bit. There's a whole thing here on foundlings, which is one of the ideas of that we have no parents, so we're being treated as foundlings. And the idea here, they have to be satisfied every reasonable effort has been made without success to identify the child. Well, I don't know how they can claim that based on, you know, the fact that people are there and everything else, but it may be a game. But again, there's a whole process there with regards to foundlings. Registration of names or an amendment to a registration of birth. Okay, so again, the whole idea that you can not only register but amend is there within the Act. And to correct a mistake or confusion, well, I'm being confused with a dead entity. I don't want to be confused with a dead entity. I need my content, my documents corrected, etc. The Registrar General must register the birth or refuse to amend it and notify the applicant promptly. So again, they have duties to follow, they have processes to follow, and it's laid out in the Act. If they refuse to amend, then the applicant has with 30 days after receipt of notification of refusal to appeal the refusal. So again, you can ask for an amendment, they have a duty to give you notice, and you have the right within 30 days to appeal if they refuse to amend, but you have to, again, exercise it within that 30-day time frame. There's more here with regards to the process of appealing. Amendments with respecting given names. So they're treating the surname separate from the given name. And again, amendment process is there. The child after has reached 19 years of age may apply to the Registrar General for an amendment in respect of a child's given name by providing an affidavit in the form required and other documentary evidence. So that's the process that is applicable to me with regards to amending the name is, and those are things I've got affidavits for my parents, I've got my own affidavit, etc. for that. Okay. After reviewing it and confirming it's made in good faith and payment of prescribed fee, the Registrar General must amend the child's registration of birth. So the process for amending the registration of birth and correcting it is through Vital Statistics in British Columbia directly to the Registrar General. Now you can only amend under this section in respect of a name given to the child before the child reached 12 years of age. So I was given my name before the age of 12, so I can amend that, that name that was given to me. An amendment to registration of birth in respect of a given name must not be made except as provided in this Act. So you have to quote the sections of the Act and say, pursuant to Section 10 of the Vital Statistics Act, I'm asking for this amendment, and here's my affidavit, yada, yada, yada. All right, stillbirths, there's information about that. Registration of adoption, there's information about people who have been adopted. Notice of adoption. This was interesting. Adoptions under treaty First Nation laws. If a treaty First Nation makes a law, so they're basically saying the treaty First Nation is their own law system and can make its own law in accordance with its final agreement with the province for the adoption of children. The treaty First Nation may give notice to the Registrar General. So the treaty First Nation has the right to make their own laws, and they have the option to give notice to the province or not. This is one of the evidences of the fact that they are independent for making their own laws and not obligated to report to the province. Special Register of Adoptions, there's a special register for that. Birth certificate after adoption. Registration of marriages. Here's another thing I've talked about years ago. Registration of marriage. A marriage solemnized in British Columbia. Now, solemnized is a very specific word, again, of legal significance. Solemnized means that it's a civil marriage. You went and got a marriage license from the province in order to not in order to get married, but in order to register your marriage in the civil system. So a marriage solemnized in British Columbia must be registered. So if you want it solemnized, if you want a civil ceremony, then it must be registered. If you don't want it solemnized, you just want a religious ceremony, then it doesn't need to be registered. So again, there's two worlds here. A person authorized by law to solemnize marriage in British Columbia must immediately after the person solemnizes marriage prepare a statement in the form required by the Registrar General respecting the marriage, and which statement must be signed by all the following. So, a person authorized. Who is a person authorized? A person authorized is any JP who does marriage ceremonies. He has a license to marry people. Any priest or whatever religious faith who has a license to marry people. A person authorized by law to solemnize is somebody who has a license to marry people. And so they have a duty to prepare a statement and notify the province that they have performed the marriage. The person who solemnized the marriage must provide the registrar with general with a statement completed on subject to within 2 days after the date of the marriage. On receipt within 1 year from the day of marriage of a completed statement respecting the marriage, the Registrar General must register. So the guy who has a marriage license to marry people can only marry people who have gone to get a civil marriage license. He doesn't have, unless he's a religious and can just do religious ceremonies. So you only need a marriage license if you're going to be married by somebody who has a license to marry people. It's a connected thing. And the obligation is on the guy marrying people, not on you to get a license. And he has to, within 2 days, give notice to the Registrar General, or excuse me, give a statement to the Registrar General. And the Registrar General has a whole year in order to register. So he's gotten it 2 days after, but he's got an entire year to register. What's that 1 year for? Is there some sort of process within that one period that somebody could exercise to not have it registered in civil or something like that? So it's kind of like if you don't show up with within 1 year to claim it or whatever, I guess they just take it over. So I think that 1 year, and it comes up in one other place. Marriage registration after 1 year. Now notice the difference here. Again, registration of marriages. Marriage registration. See, 180 degrees, one in front of the other, and then reversed. If a marriage is not registered, a marriage solemnized, are they talking about two different types of marriages? Yes, they are. This is the one with the marriage license. This is the one without a marriage license. If a marriage is not registered within 1 year from the day of the marriage and application for registration of it is made by any person, could be anybody, to the Registrar General by affidavit accompanied by a statement in the form required and other evidence, the Registrar General must register the marriage if satisfied with the truth and sufficiency of the matters stated in the application. So anybody could give them notice of your marriage or somebody else's marriage. marriage. I wonder what type of person would do that. It's not just the parties, it could be anyone. So it's optional to register a marriage for somebody who does not have a marriage license, and it's mandatory for one with a marriage license. Particulars of death, there's stuff here with regards to death we won't go over. It's in medical certificates. And registration of death can be made by any person. So it's a wide open door there. Now, this section here was interesting. On receiving a court order that declares a person to be presumed dead for all purposes, the Registrar General must register the death. So here's the open door for if they declare us dead, because we haven't shown up, we've been missing for 7 years, they declare us dead and they take over administration of the estate. That's one thing there. If requested by the Chief Electoral Officer, because there's a process here, anybody declared dead, Chief Electoral Notice gets notified, so they take him off the rolls. Objection to the registration of a voter or an elector. There are two different forms. One is the private and one is the person. An elector is the man and a voter is the registered person. So there's something in there as well for that. Birth or death on an aircraft or ship. If the birth or death of a person occurs on an aircraft or ship whose first stop after the birth or death is in British Columbia, the Registrar General may register the birth or death. May. It's not even a mandatory. So think about it. If the whole Admiralty thing is in place, and they deem the fact that it's some sort of ship that we've been born in, they can register it as well there. What's that other one? Amendment to the name. There's a whole thing, how to change your name under the Name Act. This is not what we're talking about. We're talking about correcting the vital statistics record, not changing your name under the Name Act. So it's a whole different deal. Registrations fraudulently or improperly obtained, the Registrar General may order that it be canceled. So you can check into some notice with fraud there. Now here's another whole section, 29, corrections of errors and omissions. If on receipt of an examination of a registration it appears to the Registrar General that an error or omission exists in the registration, the Registrar General must inquire into the matter and may correct the error or omission on production of evidence of the error or omission satisfactory to the Registrar General. So this is the whole idea of correcting the errors with regards to the style of the name and with regards to the parentage for any presumptions based on the structure of the form. If after registration has been filed, it is reported to the Registrar General that an error or omission exists in the registration, the Registrar General must inquire into the matter. He's mandatory and may correct the error or omission on production of evidence of the error or omission satisfactory to the Registrar General, verified by affidavit on payment of the prescribed fee. So again, there's a process. You've got to give them notice through this material to back it up, and then pay the required fee, and they have an obligation to investigate it. After the correction is made, certificate must be prepared as if the registration had been made containing correct particulars at the time of registration. So it goes right back to the beginning and corrects it ab initio, from the beginning. Must include both, let's see, a photostatic copy or print of the registration must include both the original information and all amendments made under subsection 3. Now, when you get your registration of live birth, you're only getting the front of it, and there may be amendments on the back. There may be information on the back that they haven't provided to us. And then there's an appeal process. If there's a decision you don't like, the appeal process is laid out here, and birth certificates, what must be on it, etc. Marriage certificates, what should be on it. Death certificates, what should be on it. Certificates generally, okay? If you believe the document is to be used for an unlawful or improper purpose, well, I think they're using it for unlawful improper purpose right now, and the way they're using it. So that's another thing to raise with them. Cancellation of the certificate, process for that. Certificates are copies as evidence. Information sharing agreement, they can share information, get this, with a public body in another jurisdiction, a prescribed body that is public in nature. There is some people who have commented that when you go set up a bank account, they access your birth certificate to see what your status is. And they can get it in electronic form or hard copy form. So that's what this whole information sharing is about, is it gives other parties the right, an agency or ministry of the Government of Canada, the province, including Crown Corporation, educational body, schools can access a copy of the birth certificate and certificate of birth, healthcare, etc. So this whole idea that that matrix document sitting there and all these official organizations can access it to confirm where your status is and where you fit into the system, and also possibly to access the number in order to tap into the account, whether for your benefit or not. So the information sharing agreement is interesting as well. They can require the attendance of a person to provide in-person testimony if you provide an affidavit. Records are property of the government. All records, books, and other documents pertaining to any office under this act are property of the government. This is more with regards to the office holder having the property, but this also applies to the actual documents themselves. The certificate of live birth, registration of live birth, the birth certificate, they're all property of the government. Establish forms, okay? The Registrar General may establish forms, so that's writing to them and saying, what's the form for me to do this process under Section 7B of the Act? And failure to carry out duties. Here's that penalty section. A person who fails to give a notice, or to furnish any statement, certificate, or particulars required under this Act within the time limited by this Act commits an offense and is liable on conviction to a fine of not more than $50,000. If more than one person is required to give a notice, or to register, or to furnish any statement, certificate, or particulars required under this Act, and the duty is carried out by any of those persons, the other or others are absolved from the performance of the duty. So remember, the section said duty was for the prescribed persons, and then the statement was not a duty, it was just a statement to be made. And the obligation was on the hospital to fulfill the duty of the other parties if they fail to do so. So the hospital is the one who's on the hook for the $50,000, and it says here that if any party gives notice or statement, then nobody is liable. So the idea is, as long as somebody reports, there is no penalty. The only penalty applies when all of the ones with the duty fail to do their duty. And it's, again, probably standard procedure for the hospitals to do it immediately after the birth. Person who willfully removes, defaces, destroys a public notice relating to the registration of birth, stillbirths, major deaths commits an offense. So if you post a notice, they can't interfere with it. Prohibition against other registration systems. A system of registration of birth, deaths, or marriage must not be maintained or continued in British Columbia other than is authorized by this Act. So they can't, no private system can authorize it, although historically common law is Bibles. Family Bibles are the lawful version for registering birth, death, and marriages. And it's not a system, it is a private method to do so. Lieutenant Governor Council may make regulations prescribing evidence. There's always class of persons stuff, establishing classes of persons and making regulations that are different for different classes of persons. Well, a class of persons is a natural person. That's a class of persons. An artificial person is a different class of persons. Trustees are a class of persons. Decedents are a class of persons. So we want information about the natural person class of persons here. And there's some stuff here about adopting, by reference, whole or in part, any changes from regulation, code, or standard or rule enacted under a law of another jurisdiction, including foreign jurisdiction, set by provincial, national, or international bodies. So this is where they can pull in and go, we're following the rules from this jurisdiction over here. And that really gives them lots of leeway as well. Now, we're at the end of my regularly scheduled time, but I'm going to open it up. If you have any questions about any of that stuff, I went through it fairly high speed, but like I said, I want to give you an idea of what to look for and how to go through an act quickly in order to look for those keywords, those dual capacities, the mandatory versus the optional, etc., and search in your own act for it, for the amendment process. I believe that the amendment process is what needs to be done, and so it's important to find it in your local jurisdiction and discern what section to point to when you write to whoever it is. It's probably the Registrar General in your jurisdiction for the correction of the record. All right, so everybody's unmuted. Oh, hi, Maria, welcome. And I'm unmuted Maria, so if anybody's got any comments, you can mute yourself if you don't have anything to say. If you have any questions about that, shoot. I don't know where you came in that, Maria. I didn't see how long you've been with us. So, and Robert and Connie, how you doing? I think you guys are unmuted. Yeah, yeah. All right, let me look at my text here. Great stuff. So what exactly would we be wanting to amend? All right. The amendment is with regards to parentage and the style of your name. Because the forms appear to be set up to separate the mother and the father, so they do not appear to be married, or only one person is filling out the record. And when you look at the stuff we just looked at there's all those different ways to fill out the record or the form. The way the form is filled out doesn't qualify as a properly completed statement. So it fails as a proper filing from their own standards, the way it's filled out. So in order to correct, the main thing is that I got an affidavit, both my parents are living. I got an affidavit from each one of them stating that they were lawfully wed. I didn't talk about anything with regards to a civil marriage, only they were lawfully wed in a church in front of witnesses, and that my mom gave birth to a living boy, gave him this given name, and so on. So all the lawful common law facts that you want to establish of your parentage, so that they were lawfully wed, which means that you're not a bastard child of an unwed mother, and also the location, in my case, the County of Vancouver, which is the lawful jurisdiction. So everything, putting it into the lawful side of things. So the lawful marriage, the lawful jurisdiction of the location or place, and then the filling out of the form, intending it to be complying with what they believed to be something that was required, but without understanding or knowledge that it was going to be used for any other purpose. That was another thing that I put in there. And that the form was completed in all capital letters, which was incorrect, and should have been done in this style, and then quotation marks, upper and lowercase name. So all of the assumptions and presumptions that we've heard about that they may be operating under, you want to correct and take away with your affidavit. So whatever those may be, then you make a point for it in your affidavit. So my parents have specific points in theirs that I drafted for them, and they proofed it and confirmed everything, and I edited it, and then they signed it, etc. And then I have my own affidavit restating my present status and my present understanding and my parents and so on. And so the affidavits are to establish lawfully wed, living, given name, properly styled. Those are the things that are the biggest, and lawful jurisdiction. Those are the biggest corrections for me in my understanding at this point. And the other thing is that may not be everything, because I've not gotten a response back yet from the Registrar General, because it says in here, in the prescribed form, with the prescribed information, as required, that type of stuff. So communicating and saying, based on this section of the Act, it says there's a prescribed form, and you need information. Well, provide to me the form and tell me what information is needed in order to do the amendment process. And so by sending that off, you're asking the person who's mandated by law to provide you with that information, the process for it and the forms for it. So these things are not generally available, the forms, etc. So you have to ask them for it, and it's, again, in the Act. Now, there's a regulation here associated with it. Place of birth means the municipality. Now, the municipality is corporate or other designated area. That's why I'm using County Vancouver. That's a lawful jurisdiction, not a corporate jurisdiction. So you can see how there's duality in everything. So it's not that the statutes are bad or wrong. They have to deal with and acknowledge the lawful side of things at the same time they're setting up their fiction game. So you find it. Now look at date of birth. It means the day, month, and year, which is, again, a specific order, day, month, and year, instead of month, day, year. Let's see. And this other thing, sought to be registered. Maybe I don't seek to register. Right? Isn't if it's mandatory, I'm not seeking to register. I have to register it. So there's a voluntary aspect in here that they allude to. So again, there's a 30-year time frame in here. There's a 4-year time frame. Here's where incapable stuff is. Delayed registration of marriage. What to do about that? Delayed registration of death. Duties of district and deputy registrar. So there's information in here with regards to what they have to do in their duties. And again, those are their duties, nothing to do with you, but you can hold them to their duties if you know what their duties are. So there's another open door here. Persons designated under the Act, okay, the Government of Canada. Now look at, this is a lowercase g. Most of the time you'll see an uppercase G, Government of Canada. That's a different title. This is something, but it's not the uppercase G one. And they also go, anyone who is carrying out essentially the same or similar duties functions as the director. So this is where they open the door to corporate officials. So there's nobody holding the office. So you have somebody who is carrying out essentially the same or similar duties. And it leaves room for them to plug in there some corporate officer instead of a lawful office holder. And here's Schedule B with their fees, and for the alteration or addition of a given name. So I'm looking for an alteration in style. It's $27. Or correcting an error. I'm looking at correcting a couple of errors with regards to parentage and so on. And this is where, in the information sharing, look at this. They have standard format data is requested by a person not acting on behalf of the ministry or agency of government. So they can get data from your file because they're some type of agency or they have some type of inquiry. And this, again, is what I think the courts are doing and the banks are doing, and your corporations, when they hire you, is they're accessing your birth record that has not been corrected. And they're doing it in electronic extract is what's one of the things that's available to them. So interesting stuff to know. So we're a few minutes over. If there's any more questions, we'll leave you with that. But like I said, I think that this particular concept and process of correcting the record of the registration is key to everything, because this is the beginning, this is the root of it, this is the foundation document that creates the person in the system and creates the estate or the trust or the organization or whatever you want to call it that is being operated out there that they're deeming us as the liable party for. And if we correct the record and take over operating it properly, or have them assign a trustee in order to give them instructions on how to operate it, I think that that's a good path to walk down. All right. Question here: do you think we can request a list of all agencies that have requested and been provided a copy of our certificates? Yes, that's a very good question. There is freedom of information stuff that everybody you've ever done business with, you can do an FOI. Actually, no, freedom of information is when you're asking about the government or it's public information that's on file somewhere. There's a privacy information request, which is personal to you. You can make a privacy information request through to anybody you've had a relationship with, any corporation that you've worked for, any bank you have had a relationship with, any government agency you've had a relationship with. It's basically, I had an account with you, or I had this relationship with you. I want you to provide me all the private information related to me that you have on file. So yes, you could definitely do that. That schools, same thing. Going back and finding out what they had on you with regards to the schools as well. So yeah, it's a good thing to do. Driver's license, find out what they have, etc. So definitely, that is a good thing to do, I think, is to find out what's out there and what they have to do that, to do whatever they do with. And I'm hearing more about this as well, where kids who are getting their names changed or excuse me, corrected, the schools are dealing with them differently as well. Because they're no longer wards of the state, and they don't get to own them in the school like they do kids who are wards of the state. So all sorts of things can change with that. All right. So I hope that's helpful. It's I think it's a big piece of the pie. There's been stuff about this for a long time. There's a lot of people working quite heavily on this as well. And there's some stuff with regards to land titles as well, whether or not stuff is registered in land titles. There's this whole thing about the life estate, and I talked recently about Downton Abbey and being lord of the manor and a landed gentry. If you owned land and you were in the wealthy class, you owned land, you were called landed gentry. They were the ones who had the right to vote and full rights and all that sort of stuff. So the idea of owning land and having that registration somehow associated with land ownership, and ultimately you're the ultimate land to own, because that's what you are. You're the dust and the water that came from the earth that we live in and on. Okay, any more questions? Feel free to jump in. Otherwise, we will close it down for now.